Good afternoon and welcome to today's presentation, How to Select an Expert for Patent Litigation. Before we begin our presentation today, I would like to take a few moments to go over some housekeeping items. We will be recording this webinar, and this presentation is CLE approved, and we will be asking you to enter a passcode for CLE credit a few times throughout the presentation. In today's webinar, Mr. Cumming will discuss expert witness fees, how to find an expert, what you might need from this type of expert, expert reports, deposition testimony, and expert opinions. To give you a little background about our presenter, Duncan Cumming, he is the president of Emmanuel Avionics Incorporated in San Pedro, California. He has been in the business of electronic design since 1979. Dr. Cumming's core business is in the design of electronic controls for the unmanned air vehicle market, including inertia measurement, autopilots, electrical power controls, RF systems, and video technology. These technologies are mostly applicable to the civilian market, although some UAVs do have military applications. For those of our attendees who require a code word for tracking purposes, the code word for today is expert. During the presentation, we will take short breaks, and during that time, we will ask that you enter this code into the chat feature for CLE recording purposes. The chat feature is located to the right of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself. If you have attempted to log on and have received an error, or if you are listening via telephone, please email the passcode both times that is requested, and please state the time that you have entered your code and your email. Also, please remember to complete the survey that will appear on your screen at the end of the presentation. As a provider of CLE credits, we are required to have supportive information that you have attended, and in many states the survey is required. Mr. Cumming welcomes your questions. Please use the chat feature to submit your questions throughout the presentation. We will take intermittent breaks so that Mr. Cumming can respond. Thank you all again for attending today, and Duncan, the presentation is now turned over to you.
Well, good afternoon, ladies and gentlemen. This is a talk about how to select an expert for patent litigation, and I am Duncan Cumming, President of Emmanuel Avionics Incorporated. If I could find how to change the slide here. Here we go. Now, in order to be effective, an expert witness should have a relatively narrow area of expertise, but be a recognized authority in that area. It's not usually the case that the best expert is a generalist. What you're looking for in an expert is an individual with the appropriate education, training, experience, and practical knowledge to assist the trier of fact in understanding technology issues relative to the litigation. Because the testimony and opinion of an expert witness can carry great weight in the final outcome of litigation, it follows that they are an important part of the litigation process. Important characteristics of an expert witness include good knowledge of the relevant field, exceptional communication skills, fairness, and objectivity. An expert is one who brings their own opinions to bear on the technical issues. An expert witness is not an advocate. Advocacy is a job for the attorneys. While the initial selection of an expert is performed by the litigation team, the decision as to whether you are an expert and if you have the requisite expertise to give testimony rests not with the litigation team but with the judge. Most instances of either criminal prosecution or civil litigation need an expert witness. Expert witness support is important in any dispute where technical issues are key. Expert witness support is vital in matters of intellectual property, such as copyright infringement, theft of trade secrets, or patent infringement. Now, when you're engaging an expert witness, the key to it is early engagement and get a start early on during the process. Technical jargon will be used by the opposing expert witness as well as the fact witnesses. So it's important to have a subject matter expert on the team in order to interpret this technical jargon. It is vitally important that the attorney litigating the case is clear about the meaning of these terms so that he can see how they apply to and impact the evidence. The patent claims construction is the main place where these terms are used in a patent case. The professional experience and expertise of the expert witness is the only possible source of this assistance if the attorney does not have a background in the applicable technology herself. The attorney needs to craft meaningful interrogatories that can go to the heart of the technical issues involved in cases that involve highly technical issues. For this reason, the expert witness should be engaged and briefed on the details of the case well before the deposition of fact witnesses. Now, there are four main types of expert. Starting off with the testifying expert witness. If the witness needs to testify in court, the attorney-client privilege does not apply. The expert witness's identity and nearly all documents used to prepare the testimony will therefore become discoverable. Usually, an experienced lawyer will advise the expert not to take notes on documents, because all of the notes will be available to the other party. An expert must satisfy the requirements of the Federal Rules of Evidence, Part 702. Generally, under Rule 702, an expert is a person with scientific, technical, or other specialized knowledge who can assist the trier of fact, which is typically a jury. A qualified expert may testify in the form of an opinion or otherwise, so long as 1. The testimony is based upon sufficient facts or data. 2. The testimony is the product of reliable principles and methods. And 3. The witness has applied the principles and methods reliably to the facts of the case. Now, the second type of expert witness that you can have is a consulting expert witness. A party can hire experts to help them evaluate the case. For example, a car maker may hire an experienced mechanic to decide if its cars were built to specification. This kind of expert opinion will be protected from discovery. If the expert finds something that is against its client, the opposite party will not know it. This privilege is similar to the work product protected by the attorney-client privilege. The non-testifying expert can be present at trial or hearing to aid the attorney in asking questions of other expert witnesses. The third type is the economic or damages expert, and the economic or damages expert will bring decades of experience with business valuations, economic and quantitative analysis, and market assessments, including the assessment of economic damages in commercial disputes, medical malpractice, intellectual property, product liability, personal injury, and wrongful death cases. Depending on the matter, the economics or damages expert will be brought into the matter either very early or late in the case calendar after the fact discovery is concluded. In patent litigation, it is once again important to bring this expertise to play early in the proceedings to establish the damages to be applied to allegations of patent infringement. Now, the last type of expert you can have is a court-appointed expert. Now, according to the Federal Rules of Evidence, Rule 706, a court can appoint any expert witness agreed upon by the parties or upon its own selection. An expert witness will not be appointed by the court unless the witness consents to the act. A witness so appointed will be informed of his or her duties by the court in writing. An expert witness will advise the parties of the findings, and the witness may be called to testify by the court or any party. An expert witness will be subject to cross-examination by each party, including the party calling the witness. The role of such an individual is to educate the judge about technical arguments presented by the expert witnesses retained by the opposing party, and to help the judge frame questions to them. I have been both a testifying and a consulting expert witness. Now, having covered the types of expert witness, we now go into how to utilize them. And if you're the plaintiff, we see the ways to utilize them on this slide. Claims construction is performed before the actual litigation to demonstrate how the accused product infringes the patent claims. The expert assists the litigation team in this process. The analysis of infringing products is another area where the expert's skill and experience can be used. The Markman hearing is used to determine which claim constructions are used, and the expert works with the litigation team to define the patent claim terms and to develop the claims charts. Another use for the expert is to attend the depositions of fact witnesses and the opposing team's expert. Here, the expert assists the litigation team in understanding the testimony of the fact witnesses and the opposing expert, and also in developing relevant technical questions. An expert report is produced by the expert to quantify their position, and this report is then defended at deposition. The defendant will also assert patent validity arguments based on prior art, which the expert reviews and writes a rebuttal report which speaks to the relevance of the defendant's prior art and the patent claims that are asserted in the case. Expert testimony is given at trial, deposition, and Markman hearing. We now move on to the actual patent itself, and this is about infringement cases. As previously mentioned, the expert witness is used to help in the claim construction so as to help lawyers get the most favourable definition of terms used in the patent. Typically, a party other than the patentee or licensee of the patentee that manufactures, imports, uses, sells, or offers for sale patented technology without permission or license from the patentee during the term of the patent and within the country that issued the patent is considered to infringe the patent. In general, the test requires that the infringing party's product or method or service and so on falls within one or more of the claims of the patent. The process employed involves reading a claim onto the technology of interest. If all of the claim's elements are found in the technology, the claim is said to read on the technology. If a single element from the claim is missing from the technology, the claim does not literally read on the technology, and the technology does not infringe the patent with respect to that claim. Now, how the expert can be utilised by the defendant is shown here. A response to the pre-litigation claims constructions must be prepared by the legal team, and the expert can assist in this process. The plaintiff does not construe or interpret each claim according to the meaning of the words the author used, but rather what the notional addressee would have understood the author to mean using those words. And because of this, it gives considerable scope for an expert response. Now, as products are alleged to infringe claims of the patent, the expert helps in the analysis of these products and then assists in the production of an expert report in order to respond to the allegations. The expert also assists the litigation team in identifying and analysing prior art that can be used to develop validity arguments. It is important that the expert have knowledge of the industry at the time the patent was granted in order to locate similar products. The most cost-effective way to approach this is to use a search company to find the prior art, then the expert to analyse it. Now, patents can be up to 20 years old, and so it's important to have somebody who has been around the industry for a while so that they know what it was like at the time the patent was granted. As the case moves forward, the expert works with the litigation team in defining the terms used in the patent claims for the claims construction Markman hearing. The expert witness is very useful in attending the depositions of fact witnesses and the deposition of the plaintiff's expert to assist the litigation team in developing relevant technical questions and understanding the testimony of the participants. An expert report is produced by the expert to quantify their position, and this report is then defended at deposition. Expert testimony is given at trial, deposition, and Markman hearing. Now we move on to invalidity, which is simple in the case of a single prior art. The claim is applied to the accused product, and then every element of the claim reads on a prior art device or system, then in that case the claim is invalid because it lacks novelty. If we have multiple prior arts, the situation is a little more complicated. it's quite possible that most of the elements of a plane read on a prior art device or system, but not every element. But it's possible that the remaining elements are also present in other prior art. So the situation you have here is that you're trying to use two pieces of prior art for one claim of one patent. Now, you're allowed to do that because the claimed invention may still be invalid if it would have been obvious to a person of ordinary skill in the art to combine the elements from two or more items of prior art at the time the alleged invention was made. So the expert needs to look at the arguments as to why it would have been obvious to combine the two elements of prior art in order to make this invention. These days, the usual test for obviousness is the KSR opinion, which came out a few years ago. And KSR was a company which made throttle pedals for automobiles. And the case history, case precedent, shows that the way to test for obviousness is by looking at teaching, suggestion, and motivation. The teaching is what it says in the prior art and in the patent. The suggestion is that these teachings should suggest that they should be combined to form part of the claim. And the motivation is that the inventor has some reason for trying to combine the two claims. And if one can show teaching, suggestion, and motivation, then that is one test for obviousness, and that's a way to invalidate a claim based on multiple prior arts. Closely related to this, we have the doctrine of equivalence, which is a legal test. Now, the doctrine of equivalence analysis is applied to individual claim limitations and not to the invention as a whole. The legal test is whether the difference between the feature in the accused device and the limitation literally recited in the patent claim is insubstantial. One way to determine whether the difference is insubstantial or not is called the triple identity test. Under the triple identity test, the difference between the feature in the accused device and the limitation literally recited in the patent claim may be found to be insubstantial if the feature of the accused device performs substantially the same function in substantially the same way to yield substantially the same result as the limitation literally recited in the patent claim. The doctrine of equivalence applies if two elements are interchangeable, and a person with ordinary skill in the art would have known that the elements were interchangeable at the time of the infringement. So those are the uses of an expert in a patent case. Now we go to what do you need in an expert? What you need is at least 3 years' experience in the relevant industry. You need experience in the industry at the time the patent was granted, which could have been up to 20 years ago. You need experience with the device or system involved in the patent at issue. And then you may need engineering experience or perhaps marketing experience, depending on the case. Any litigation, whether for a malfunctioning light bulb or a computer system, requires a clear understanding of those issues for which expert witness opinion is needed. It can sometimes be difficult to find the right expert for any given case, and for this reason, the search for experts should be started as early as possible in the case. The appropriate expert should be identified, retained, and then used as required going forward. Do not, under any circumstances, wait until the day before expert designation. In patent litigation, or indeed in any high-technology litigation, this can lead to disaster. If the selection of experts is delayed, it can result in a limited choice of experts, higher hourly fees, and increased travel costs. There is also a real danger that the opposing side will already have retained the best experts that are available. So, again, early engagement is key. Now we move on to the expertise itself. Obviously, one needs an expert who works in the relevant specific field, which in my case is electronic hardware. A wide breadth of experience in this specific field is, of course, desirable, but one should avoid hiring a generalist. So, as an electrical engineer who has designed a wide variety of hardware would have the required breadth of experience. A generalist, on the other hand, might be a journalist who has written many articles about computers and computing. The engineer is to be preferred over the journalist because of the experience of designing hardware and actually making products happen. This experience is critical when it comes to matters such as claims construction and infringement analysis of a patent, because patent claims are written in a very specific manner. For patents, the legal standard is one of ordinary skill in the art. So an expert need not be an industry leader or a leading guru in the field, but rather an experienced individual who knows how to design and debug the hardware and should recognize the importance of the language used in claims. Of course, it's possible to find an expert with very deep experience in the realm of, say, software, but this is not preferred if the patent at issue pertains to hardware. It can often be hard for a lay person to tell the difference on a modern system, but most experts in each of these fields know experts in the other. For example, people often come to me with software patents, and I can quickly refer them to software experts. Conversely, many of my own engagements have come from software experts who were approached with hardware problems. And highly qualified experts are desirable. But that being said, the higher the qualifications the expert retains, the better. Supposing one side retains a Ph.D., while the other side retains an individual with an associate's degree. Which expert is the jury most likely to believe? We now move on to the process of actually retaining the expert witnesses. This is the expert witness retention letter. The letter should identify at a minimum the parties involved, the scope of the work, and the fee structure. Once you have decided on the most appropriate expert for the case, some kind of retention letter is required. Most large law firms have a standard letter that they use. Most agencies also have their own standard letter. I know that TASA does. It is simplest to just use the standard letter used by the agency, which has been battle-tested for as long as the agency has been in business, which is typically several decades. In the event that this letter contains unacceptable language, or is missing some important language, then the two documents can be merged together to gain a common set of contract language acceptable to both parties. Bear in mind that there may not be sufficient time for protracted contractual negotiations, though. Some experts also have their own standard contract, which can be useful, especially if no agency is involved. The requirements of the law firm, the agency, and the expert should obviously be included in the retention letter, and a non-disclosure agreement should also be included in the same place. Now, of course, it goes without saying that the contact information of all parties involved should be included. I have had problems with that, believe it or not. But that should go in the expert witness retention letter. So we can review the engagement process. The first step is that the engagement letter is signed. Then protective orders and non-disclosure agreements are executed. The expert is briefed by the litigation team. And at that point, the expert is ready to analyze all relevant documents. The expert then consults on all the technical matters, and the expert assists in preparation of patent claims, construction, marking and hearing, expert report, and deposition of questions of opposing parties and experts. And then the expert prepares his reports or her reports. Then it's time for the expert deposition, and finally the expert trial testimony. Okay, we can pause here for some questions. Does anybody have any questions for me?
Before we begin the question and answer segment, we would just ask that all the attendees type the passcode that was given at the beginning of the presentation into the chat feature. Okay, our first question is, have you ever testified before a jury, and what kind of case was involved?
Yes, I have testified before a jury, and it was a case involving a automotive accident where there was question about the design integrity of the braking system on an automobile. Essentially, the brakes had failed, and a person was injured badly because of it. And so I was required to testify regarding the design of the braking system, which was a electro-hydraulic system. And my contention was that the design of the system was inadequate and that it was sometimes prone to failures at random. And we won a multi-million-dollar award on that case, so it was a successful argument.
Okay, and I noticed that you emphasized the importance of academic qualifications for an expert witness. So what academic qualifications do you have?
I have a Ph.D. from Cambridge University, England, and it's a Ph.D. in electrical engineering. And so I'm well set for academic qualifications.
Okay, those are all the questions we have for now. We will be stopping for another question and answer segment later on. So please continue on with the presentation.
Okay. All right, we now proceed to the issue of communication with attorneys, which sounds simple, but there can be problems with doing this. So, as an attorney, one should never assume that the expert is conversant with the legal requirements and his or her responsibilities relative to work product, privilege, and the propriety of case information. Any expert engaged as a testimonial expert should be advised that virtually anything they have ever written, either in the industry or legal context, is discoverable. The expert needs to know that they cannot write, fax, email, or otherwise provide written communication in any way, unless explicitly instructed to do so by the litigation team. Now, email is okay for the litigation team to send documents to the expert, because the team is aware of the discovery considerations. For example, it's okay to email a copy of the complaint because the opposing team already has access to this document. However, the expert should not email any kind of document to the client attorney without an explicit request, since the expert lacks the training to be certain that discovery of the document will not damage the case. Telephone conversations are the best means to discuss substantive matters. Even so, the expert should follow the lead of the client attorney about what to say. It often happens that the expert needs to contact the client attorney for some reason. The best way is to either send an email saying, "I would like to talk," and set up a suitable time, or leave a telephone message. Whether this message is left with a human or on an answering machine, it should not say anything except "please call back regarding," plus the name of the case. FTP sites, I think that stands for File Transfer Protocol, are the best for sending documents. Many experts and many law firms have such sites, which are shared by all members of the team. Any member of the team or the expert can upload a document, which is typically downloaded by the recipient, and then the copy on the FTP site is deleted. An FTP browser is needed, and many excellent ones are available for free on the Internet. Now, the main advantage is that any number of documents of any size may be uploaded, not subject to the annoying 10 megabyte limitation of most email accounts. My experience has been that if I receive a document of more than 10 megabytes by email, it can cause difficulties with the email account itself, which I have to go and sort out. And I'm sure the same applies to attorneys. And so it can be hard to tell the size of a document in advance as well. So this is a problem that tends to plague emails used for transmitting documents. Now, although FTP site documents are fully discoverable, they don't have the permanence of an email. While forensic analysis will probably retrieve any of the documents given sufficient time and expense, it will be a lot more difficult than simply requesting an email document from the opposing team. However, just as with email, the expert should not post any document to an FTP site without an explicit request. The best way to discuss proposed changes to a document is by telephone, using a conference call if needed. Okay, we now move on to the topic of expert reports in intellectual property matters. The format of an expert report is as varied as the law firms that engage expert witnesses who are required to produce expert reports. The litigation team will set the parameters for the content of the expert report, and for the patent matters, the format is fairly consistent. The compensation rate should be included in the report. It's important to include that because by stating the fee up front, it precludes the possibility that opposing counsel will try to claim in front of the jury that the expert attempted to conceal their fees. Now, the qualifications required, this might include something like a bachelor's or a higher degree, a certain number of experience in the industry, certain number of years of experience in the industry, and so forth. Remember, this is to be one of ordinary skill in the art, so a higher degree, such as a Ph.D., should not ordinarily be specified. Of course, it's better that the expert be more highly qualified, but the report itself should still be written on the level of one of ordinary skill in the art. The expert, of course, should have reviewed the patent, the prosecution history, and the prior art, and the opinions given by the expert in the report should be about what a person of ordinary skill in the art would understand by the various claims as properly construed. And then the expert report is finished with a declaration that the foregoing is true and the signature of the expert. Of course, it goes without saying that the report must be the unbiased work product of the expert alone. Now we move to the issue of testimony at trial. When this is done, the lawyer must have supporting documentation for the expert's opinion and must commit to memory all relevant information to the expert's opinion. Now, the expert's most important role is giving testimony at trial, and so it's vital that the expert follow the pre-testimony preparation. It's no good having flashes of insight or new ideas once you're on the stand. Once you're on the stand, the expert must follow what was discussed in advance with the attorney to keep both sides on the same page. And then the attorney should instruct the expert to treat the judge with respect and courtesy, and then during cross-examination, answers are not directed to the person asking the question, but they're directed instead to the judge or jury. And now we move on to the issue of International Trade Commission, or ITC. The ITC is rather different than a district court case, and the requirements of an expert are rather different from the district court's requirements. And so it's really a separate issue to find an expert with ITC qualification. Now, the International Trade Commission, which is also called the ITC or the Commission, has become an increasingly popular forum to litigate intellectual property disputes for both US companies and foreign companies with a US presence. Among other benefits, a Section 337 investigation can lead to swift resolution of disputes and the granting of broad exclusion orders. Since there are critical differences between a Section 337 investigation and a district court litigation, companies and their counsel must understand the steps of the 337 investigation, as well as the substantive and procedural rules. I myself have done ITC cases with some success. Now, the features of an ITC matter, patent infringement cases are Section 337 investigations. The ITC does other matters as well, but this talk is only concerned with the Section 337. There is no jury. This makes life much easier in a way because anything can happen with a jury. But all you have is a judge who is one of 6 administrative law judges assigned to the ITC. Now, if you want to file suit, litigating in the ITC is a very aggressive approach. The ITC has the power to issue exclusion orders preventing infringing products from entering the US. So that means that if you're a company which is producing your products offshore, say in China or somewhere, and then importing the product for sale in the USA, if you are issued an exclusion order that stops you from importing your own product, you can be out of business very quickly. so the ITC has a lot more power than a typical district court in practice. It's a more aggressive approach. Even the threat of such an exclusion order can put a real strain on the respondent's business. The other difference is that a final determination is typically issued within 16 months, which is much, much faster than the district court. So an ITC investigation is an immediate and significant threat. And because it's a different procedure than the district court, it uses different nomenclature. So experts must be familiar with the nomenclature used in an ITC matter. A case, what's called a case in the district court, is called a matter in the ITC. The plaintiff is then called the complainant, and the defendant is called the respondent. You have a branch of all ITC cases called the domestic industry branch, whereby all complaints must demonstrate domestic exploitation of the asserted patents. This is because the ITC is a trade agency that exists to protect US interests from imported knockoff goods that would infringe valid US intellectual property rights. The domestic industry requirement ensures that the protections offered by the ITC actually benefit companies with significant investments in exploiting the relevant intellectual property in the US. To satisfy the domestic industry requirement in a patent case, the complainant must demonstrate significant activity based in the US that is related to at least one claim of each inserted patent. So essentially you have to show that there's not only has the patent been violated, but also there's significant activity in the US based on that patent. And so this brings us to the requirements for an expert used with ITC. And for various reasons, an ITC matter is more stressful to an expert witness than is a district court case. The timing is very extreme. 16 months is very rapid for reaching a settlement of this magnitude. And so administrative law judges' hearings may run for 10 hours or more per day, and also on the weekend. So you just have to work harder on an ITC case if you're an expert. The other problem is that direct witness testimony is written. And so that means the first substantive live testimony that the expert witness performs is on cross-examination by the opposing counsel. This makes it more difficult and more disorienting because you're suddenly subject, as an expert, you're suddenly subject to cross-examination without previously having had any direct examination from friendly counsel. So this means that any live direct testimony from friendly counsel must wait until the redirect. It's still called a redirect, even though there is no direct, because the direct is written. The complaint must contain far more data than in district court. You need detailed infringement claim charts and contentions before even filing suit. There is no Markman hearing. So if you're filing an ITC matter, all of the claim construction has to be done before you even file it. Then you have a need a description with evidence of the complainant's domestic industry, which is not required by district courts. And you also need detailed information regarding the proposed remedy. It's no good asking the court to provide such remedy as it sees fit. You have to have a detailed plan which you submit with the initial complaint. Now, the respondents have only 20 days to file a response. So the search for experts in prior art must start immediately. The expert witness must also be able to start work very soon. So it's basically a bit of a scramble to both locate an expert and start work on an ITC case. And you need an expert who is sufficiently agile to be able to start immediately once the case is filed. And we move on to the issue of team building. For some cases, many experts are needed, and a team must be built, similar to the team on a large engineering project. It's a lot like building the team on a large engineering project. Sometimes the assignment of managing multiple experts is best given to a single attorney for maximum efficiency, while minimizing the potential for any miscommunication. Other times, perhaps for large patent infringement matters involving multiple patents, it is best to divide the tasks by relevant technology. Experts and attorneys can then be assigned to the patents most relevant to their expertise. Where large numbers of patents must be analysed to find those most likely to be infringed, this approach can be effective. Now, another problem with team building is prior art research. It's inherently open-ended, and so the time budget is important. With prior art research, there is no time limit to the number of documents that may be searched, so it's difficult to be sure when sufficient research has been done. For this reason, the time budget should be considered carefully. The most cost-effective way to proceed is to have a bibliographical team locating possible prior art, casting a wide net so that anything that might be relevant is located. A highly credentialed team of experts can then evaluate these possible hits to evaluate the selected art for suitability. This approach avoids the problem of credentialed experts having to do a literature search, while also limiting the total amount of time spent by the team. The bibliographical team can spend its time doing what it knows best, that is, finding literature, while spending very little time evaluating literature that has already been found. Now, I've done prior art searches this way myself, and I've found that the bibliographical teams are actually pretty good at seeing what's relevant and what isn't. And I typically might get about 20 possible prior arts from the bibliographical team, of which 5 or 10 are sufficiently good to actually use in the case. And it's much cheaper to have a bibliographical team working than it is to have an expert working. So this I've found to be a very good way to go. Now, experts, however highly credentialed, should not be left to their own devices with respect to research or the development of expert report opinion. While experts could certainly be given documents, patents, and other research material, and left to read and make analysis, but close supervision is required by an attorney for production of the expert report itself. Now, in a very large patent infringement or complex litigation matters, where multiple experts are engaged, consider engaging a project manager to manage the experts. I personally have never been on a case that large, but it certainly can happen. Okay, now another word here about word of mouth. Nobody disputes that word of mouth is the best way to find an expert witness. Word of mouth is the best way to find an expert witness, but it may or may not be possible depending on your specific case. Attorneys often hire expert witnesses who performed well in the past who work on subsequent cases. However, for patent work, the new case may differ from previous cases to such an extent that the expertise of prior expert witnesses is no longer appropriate. Another possibility is to ask experts who have opposed the attorney in past cases. Attorneys will take note of effective expert witnesses they have come up against in the past, and will often hire that expert witness to work on their own side in future cases. Do not forget to ask the client himself for referrals, because sometimes the attorney's client can recommend an expert witness, since they have expertise in the area at issue. After all, those guys are in the business. Also, when contacting an expert who is not suitable for your case, ask if he or she knows any others that may be suitable. I have received several engagements in this way, and I've also referred several other experts. Often an expert will know enough about a subject to be able to recommend another expert, even though they do not themselves possess the requisite expertise. The bottom line is that while word of mouth is probably the best way to find an expert, the number of experts you can reach in this way may ultimately be limited. Now we move to the question of subject matter expertise. The most important characteristic that any expert must possess is a relevance to the technology of the patent at issue. The test is known as the Dobut rule, and the judge is the gatekeeper. Under Rule 702, the task of gatekeeping, or assuring that scientific expert testimony truly proceeds from scientific knowledge, rests on the trial judge. To attack expert testimony as inadmissible, counsel may bring pre-trial motions, including motions in limine. The motion in limine may be brought prior to trial, although counsel may bring the motion during trial as well. A motion attacking expert testimony should be brought within a reasonable time after the close of discovery, if the grounds for objection can be reasonably anticipated. The hearing should be made well in advance of the first time a case appears on a trial calendar. If an expert fails a Doebert challenge, the hearing is of course a matter of public record, so it can cause a loss of credibility for an expert. On the other hand, if an expert succeeds against the Doebert challenge, then that can increase their credibility. So we'll take another break here for more questions.
Okay, and I would also ask the attendees to type the passcode again into the chat feature. Okay, our first question is, what would you suggest if you were having a great difficulty finding an appropriate expert and time is passing in the case?
Well, I would suggest that the best thing to do is to go to a expert agency because they have the database of a large number of experts available. The thing is to stay active on this, stay proactive on the issue, and don't hang around waiting for replies from people. So you would try an expert agency, and then if they don't quickly come up with an expert, try a different expert agency. Another way to go is you can call an expert who is only faintly associated with the case and see if they know of another expert that has the required expertise. That can be a very speedy way to find an expert. We all fit together pretty effectively.
Okay, and you had mentioned that there is no direct testimony in an ITC matter, so the first time that you speak will be facing opposing counsel for cross-examination. Has this ever caused a problem for you?
Yes, it has. It's surprisingly disconcerting when this happens, and the opposing counsel takes advantage of this. So I was at an ITC case concerning inertial measurement units, and the first testimony I had to give, basically, was to the opposing counsel cross-examination because the direct testimony had been written. And so he immediately launched off into a shockingly sophomoric discussion about women in the shower, which I would find most shocking. And the idea behind this, of course, was to disorient me so that I would be less able to testify accurately on the matters of the case, which had nothing to do with showers. It was about inertial measurement units. And so that was, to some extent, successful, and it was just an instance of the opposing counsel, who I should point out was a non-practicing entity, exploiting this fact of ITC cases. And so having an expert who is experienced in this kind of stuff really helps.
Okay, and how do you go about engaging a project manager for a large patent infringement case?
The best way is to look for people who have done project management in the past. There are many headhunting firms that can find project managers for you, and I would tend to go through one of those. I think the management of a project for a large case is sufficiently similar to the management of a large project for example, electronics, that the same kind of person can do the tasks involved.
Okay, and do you need a project manager for all patent cases?
No, by no means. You only need a project manager for a very large patent case, where there's a very large number of patents being reviewed for infringement. A typical patent case is much simpler and can be done with a single expert. The patent cases that I've worked on have always been done with a single expert for our side and a single expert for the opposing side. But I did work on the Apple computer case, but there I wasn't a testifying expert, but I was just one of the non-testifying experts that were consulted.
Okay, and how would you recommend choosing a team leader in a case?
Well, the team leader would typically be on the attorney's litigation team, and so the most senior attorney who is working on that case would be the team leader for the case. You wouldn't have a expert as a team leader. You need the experts to each report to somebody else, which should either be the litigation team or it should be a manager that's been employed by the litigation team. Essentially what I'm saying is that the experts need close supervision, and experts are not usually managers. You need to be sure that there is sufficient management available for the scope of the case involved.
Okay, and then our next question is, do ITC matters have more than one expert?
They can. I've never been on one that has had more than one expert, but if it's sufficiently large, it certainly could have. It depends on how many patents are involved and how many claims on the patent and how much research is to be done. Usually, I would say that they don't have more than one expert, but it depends on the scope of the case. The thing is, the ITC has so much power, and it can exclude, it can give out such broad exclusion orders that it's not usually necessary to have that many experts on an ITC case.
Okay, and how many attorneys should be involved when hiring an expert for an IP case?
Well, I think that all the attorneys on the team should have a say in hiring the experts, so the answer to that depends on how many experts are on the team. Most IP cases have one or two experts on the team, but one or two attorneys on the attorneys team, and all of them should participate in the decision of whether or not to hire a particular expert. Of course, it's perfectly okay to send individual attorneys or paralegals to search for experts, but before the decision is made to actually retain one, then every attorney on the attorney's team should be consulted.
Okay, and you mentioned the possibility of the expert witness providing such things as an FTP site for file transfer and an expert retention agreement. Can you provide these things?
Yes, I certainly can. I have a expert retention agreement that I have used whenever necessary over the years, and it usually works pretty well, so that's available if needed. And then I also have an FTP file site. Now, many law firms, big law firms, have their own FTP sites, and I prefer to use that if they have one, but if not, I've got one that we can use, and it's no difficulty. All you need to use it is a FTP client, which I can tell you how to download from the internet. Things go much more smoothly if you have an FTP site, because you don't get the problems of large emails, large emails can bounce, they can not be sent properly, and the files can get mangled. An FTP site just avoids all these computer problems. But the downside is that you need to know how to use them, but it's not very complicated.
Okay, and should there be two experts on an IP case, one that does the research and one to testify?
The IP case I was on did not have a separate attorney to do the research. The same one did both, and that did mean that all of my research activities was discoverable. But that didn't cause a problem in our particular case. It really depends if the expert is liable to find stuff which is disadvantageous to their own team, then you definitely need an expert that does separate research. But if I was to have thought on this case that might have been a problem, then I would have notified the team of attorneys, and they would have found a different expert to do the research. So the thing is that it's important for the expert to use caution in doing research. One way of expressing this is that the expert shouldn't go looking underneath rocks. If you want somebody to go looking under the rocks, then you need to hire another expert who is not testifying.
Are FTP sites secure?
Yes, FTP sites are way more secure than emails are. It's what an FTP site is. It's a bit like a website, and then every user has to have a password to gain access to it. So if you had, say, 10 people with access, each of the 10 people would have their own password. And it's much more secure than an email because your computer only communicates with one server, which is the server on which the FTP site is located. With an email, the emails can bounce from server to server to server all over the world, and people are looking to intercept emails. Nobody knows about the FTP site, so nobody is looking to intercept its content. So for security, you're better off than an email, and you can also, if you wish, encrypt information on FTP sites, which makes it pretty much bulletproof. I'm not saying that the NSA couldn't decrypt it, but it's proof for any legal case.
Okay, our next question is, if you find that you are not personally qualified for a given engagement, are you generally able to refer the attorney to another more qualified expert?
Yes, I have a database of other qualified experts which I've accumulated over the years, and we are continually referring cases to each other. And so I can fairly easily find a expert for a given electronics-related matter because it's a lot easier to understand electronics than it is to have the actual expertise in a particular form of electronics. So I can readily find out, for example, software is a problem we often have. It can be hard to tell the difference between hardware and software in a modern piece of electronics because the two are very closely wrapped up in what's called EEPROM. And almost all electronic devices contain microprocessors these days. And so the microprocessor operates through software. And it's hard for a attorney who's not trained in electronics to know whether the issue involved is a hardware issue or a software issue. So if I refer one of those, and it turns out it's a software issue, I can fairly easily determine that, and then I have a list of good software experts who can go and look at the code. And conversely, the software people know when it's a hardware issue that's involved, and they have my contact information as well. So in that way, it's easy for them to find me for doing the hardware cases.
Okay. When would you recommend hiring an expert for an IP case?
The thing about IP cases is that it's critical that you have an expert for nearly all IP cases. The answer is, under what circumstances? The answer is all circumstances. Now, when in time do you hire the expert? Is as soon as possible in the case. You certainly want to do it before the discovery is involved, because the expert has a lot of input into what kind of discovery is required. And so the key to hiring an expert is early engagement. And the other issue is that you don't know how long it will take to locate an expert, because sometimes you find one the first call you make, sometimes it's the 50th call you make. It just depends. So the whole key for this is particularly true for an IT matter, is to hire your expert early and start the search for the expert early. I just can't emphasize enough that you need to get a jump on this. Now, in the case of an ITC matter, it's even more important, because if you're the the respondent in an ITC matter, then you only have 20 days to respond, and your whole company is at stake. So finding expert is just paramount importance. So you need to gather together all the people you can get and just start making phone calls and find an expert. For a district case, it's not as much of a mad panic, but it's still much better off earlier than later to find the expert.
And do you have an example where a patent litigation expert was selected for a case and it did not turn out well?
Well, you can look at any case which was lost, and then all cases have a winning side and a losing side, and so it did not turn out for the losing side in all of these cases. But whether or not that was the fault of the expert is very hard to say, and I don't have any specific examples where say that things did not work out well after having hired an expert. I've been lucky. All of the cases that I've been involved with have either settled or we won. So I've been lucky so far. But of course, for every winning case is a losing case. It's what they call a zero-sum game.
Okay, and what do you look for on a CV of an expert?
On the CV of an expert, you need to look at, first of all, the qualifications they have. What you want is qualifications, frankly, that are higher than the ones of the other expert. The legal standard is only one for ordinary knowledge, for ordinary stated. Legal standard is one of just ordinary knowledge of the art. But it pays to have an expert of higher qualifications than the other expert, because then that will interest the judge and the jury more. So that's the first thing to look for. The second thing to look for on an expert's CV is how much expertise they have in the industry that you're concerned with. In my case, I'm an electronics hardware expert, and so I have got like 30 years or so of experience in the field of electronic hardware. The length of experience is important not only because of how much you know, but also because of not only how much you know, but also the knowledge that you had at the time the patent was granted. Because by the time a patent gets to court on an IP matter, it can be 10 or 15 years since the patent was granted. And it's the time knowledge of the systems at the time that the patent was granted that counts. So in other words, you look for qualification, you look for experience in the industry, and you look for experience in the industry at the time the patent was granted, which is usually known.
Okay, those are all the questions that we have, so thank you so much for answering them. I'm going to move on to the CLE information. This webinar is eligible for CLE credit in California, Minnesota, Missouri, New Jersey, and Pennsylvania. To ensure you receive your CLE credit, please complete the survey at the end of the presentation. In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and document management solutions, free interactive webinars, and research reports on expert witnesses such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and most especially Duncan Cumming for his time and effort in creating this presentation. If you would like to speak with Mr. Cumming, or if you would like to speak with a TASA representative regarding an expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. This is a reminder that we will be sending out a link to you tomorrow with the archived recording. The archived recording will also be posted in the Knowledge Center on TASA's website. If you have any questions or comments, please email Carol Kowaleski. Thank you again and have a good day, everyone.